So thank you everyone for joining the ASCOLA Noel event of 2025. This is the third time we are doing it. And this year, Giorgio told me he definitely does not want to host it again. So it's me. So I'm Thomas Cheng from the University of Hong Kong. I'll be the chair of the panel today. And we have an awesome panel of speakers. And thank you, John and Vicky, for waking up early in North America. Thank you, Soojin, for staying late in Seoul. And no thank you to Maciej because it's 2 o'clock in the afternoon in Warsaw, but that's okay. But yes, so we have a great panel. And so let me introduce our speakers briefly, and then we will move on to the discussion. So first we have Maciej Bernatt, who is a full professor of law at the University of Warsaw. He holds a chair in European Economic Law at the Faculty of Management, University of Warsaw, and is the director of the Center for Antitrust and Regulatory Studies. He's also the co-director of the ASCOLA Central European chapter. And then we have Soojin Nam, who's an associate professor at Hanguk University of Foreign Studies in Seoul, South Korea. Prior to joining the university, Soojin practiced at law firms in New York and Seoul, advising clients mostly on antitrust matters. And lastly, from August 2023 till August of 2024, Soojin was a visiting scholar in residence at the USC Gould School of Law. Next, we have John Newman, who's the Herb Chair of Excellence at the University of Memphis School of Law, and as well as the member of the advisory boards of the American Antitrust Institute and the Institute for Consumer Antitrust Studies at Loyola Chicago, and of course ASCOLA. And John has served on both the antitrust division of the Department of Justice and the Federal Trade Commission, and most recently as the deputy director of the Bureau of Competition of the FTC. And last but not least, we have Viktoria Robertson, who is a professor of competition law and digitalization at VU Vienna. She's the director of the Competition Law Hub, and which I had the honor of being part of for a few months 2 years ago. And if anyone is looking for a place for sabbatical, I highly recommend it. Vienna is amazing. Vicky is a great host. But anyways, I'll stop the advertisement. And she is currently on research sabbatical herself at the University of Montreal and the University of Sherbrooke in Canada, researching on a monograph actually on this very topic of politics and competition law, democracy, and big tech. So, so I assume most of you know that the topic of the discussion today is politics and competition law. And we feel that there's probably no more appropriate time to discuss this than now. And there's definitely been increasing politicization of antitrust, of competition law in the last few years. I think our field is a very far cry from the late 2000s when Professor Dan Crane from the University of Chicago, of Michigan, used technocracy to describe antitrust. I'm not so sure if we are really as committed to a technocratic approach as we were, and politics have definitely become more relevant across the world. And so today we would like to have a discussion about this with our 4 speakers. And so I guess the first question we should start with is, what is the relationship between politics and competition law? And the tone of the discussion always seems to suggest that it's a bad thing, but is it? And so what is the role of politics in competition law? What political role does competition law play? And what should the rightful relationship or fruitful interaction between the two be? And also, is political a meaningful term when it comes to competition law, when many would say it is inevitably political because it is essentially a set of laws that deal with allocations of power in society? So I guess the first set of questions deal with what is the relationship between the two? What should it be? And is politics a bad thing in competition law? And so we will speak in the so John will speak first, and Vicky, then Maciej, and then Soojin. So John, please.
All right. Well, thank you, Thomas. I suspect you picked me first since the US seems to be, for better or worse, out on the forefront of this highly politicized antitrust and competition world in which we find ourselves. And I, I think without attempting to define what political means, I think we all have at least a general sense, right? I think we're probably all meaning, at least to some extent, the same thing when we talk about that. Um, I do think it's worth reminding ourselves, and I have to remind myself at times that politics is not separate from competition law, right? Politics has never been separate from competition law. As much as we might have liked to think that in the kind of 2000s, even the early 2010s, I think that feeling or that vibe still prevailed. It's never been true, right? So in the US, politics gave us competition law, right? Antitrust law didn't just emerge from the brain of economists. It was given to us by a political movement. It was an interesting allyship between workers, small kind of yeoman farmers, right? The Jeffersonian ideal, who banded together in the Granger movement, aligned with labor movements throughout the US to try to push back against the corporate consolidation of a previous Gilded Age. Right. So politics has never been separate from competition law. I think that's kind of point number one to remember. It gave us competition law. And it's still like all throughout history, it has given us our leadership, right? Politics always gives us the leaders of antitrust or competition agencies. And leaders always enjoy at least some discretion when they're setting enforcement priorities because they're allocating scarce agency resources, right? They enjoy some discretion. And that means then that politics has ramifications for competition law. It always has. That's never been untrue. It's always been conjoined. I think the second part of your question, Thomas, is also a really interesting one. So we know politics does play a role in antitrust as it's enforced on the ground. It's also true that I think the inverse, right? Competition law plays a role in politics in multiple ways, right? I think competition law, when people are exercising that discretion, it has an important expressive value. It says something about what either a particular political party or a society values, right? What we believe, where we want to choose to spend our enforcement resources in a scarce resource environment says something about what we value and what we believe. I think that's really important. Second, I think in the US in particular, competition or antitrust law could plays this kind of interesting moderating role. So throughout the heyday of really strong enforcement in the 1950s and 1960s, oftentimes people pointed to strong antitrust as a bulwark against the rising tide of communism or oh my God, socialism, right? So antitrust can play this important moderating role between more extreme governmental approaches or industrial policy approaches. And then third, I think in the US, and this is kind of less well appreciated, and this is my ray of hope amidst a dark time in US antitrust. Everyone saw the news about Meta just the other day. Antitrust can also play politically an important transitional role, right? What do I mean by that? When we are in a period where we're casting around for policy solutions, and I think we're in one of those periods now, we were in one in the 1910s. People often look to antitrust as a early or initial solution. It's like a one size fits all. Hey, we can use antitrust to fix everything. I think antitrust sometimes, at least in the US tradition, has needed to be tried and then found wanting. We need to try it and then it needs to fail in order for us to move on to something more muscular, a more whole of government, to use the current lingo, approach, so that we're not just trying to put too much on antitrust. That happened in the 1910s. We had a serious problem with economic inequality in this country. We tried more muscular antitrust in the form of new statutes, a new agency, the FTC. That basically failed and yielded the 1920s a huge era of inequality and wealth disparity that led to the Great Depression. I think we needed to try antitrust and have it fail so that when we hit the Great Depression and we were in a true emergency, people couldn't just say, oh, just try antitrust, that will fix everything. That had already been tried and failed. And we were able to adopt, I think, a much more fulsome set of policy solutions that needed to include strong antitrust, but couldn't only include strong antitrust. So that's kind of my last pitch, is that antitrust can play a variety of roles, and it should play a variety of roles. And some of them may be sort of transitional. I'm not saying we're the side dish, but maybe the transitional dish, the appetizer maybe. And so I think that leaves us with, hey, the right relationship is not totally separate. It is a healthy understanding of all the roles that antitrust plays in society.
Right. That's very interesting. Antitrust as a transition phase. That's a very original idea. If we get more time, we'll certainly explore that. But so, Vicky, now on to you.
Thank you. So for some context, as many of you know, I'm a European scholar, so obviously I bring a distinctly European perspective to this question. But I have been, as Thomas said, on a research sabbatical here in Canada for most of this year. And so I have been able to observe more closely what has been going on in, well, let's say North America. Before we get into the nitty-gritty, I think it is important to have a shared understanding of the core terminology here. So I will attempt to define what I understand by politics when I talk about it. So when I refer to politics, I understand the processes and the structures and the activities through which we as a society make collective decisions and allocate resources and exercise public power. So in a democracy, politics has to follow democratic rules of participation to achieve this. And now competition law, of course, those are the legal rules that we research that to preserve the market mechanism, that maintain or reinstill competition among companies, and that, importantly, constrain private power. And within competition law, I would say, if we think about the role of politics, we need to think about two dimensions, the law and the enforcement. The law as it stands is a statutory law, so it's been adopted by the legislator. And like John already mentioned, this happens through political processes, but they do need to fulfill certain democratic criteria. And of course, importantly, certain goals are baked into the law. So this is a political and normative question that we have to answer here. And it is something we like to debate at length in competition law, and for good reason. And this is where politics can and must intervene. And other than that, I think politics' role is that of ensuring that competition law enforcement remains democratically accountable. Now, somewhere between law and enforcement, there's the case law, of course, developed by the courts over decades, sometimes centuries. And of course, courts themselves are political as well. And perhaps I'll come back to that later. But this is not the domain of politics as I just defined it. So if we see attacks by politicians, by holders of political office on the courts, then this is misguided. And frankly, it's a slippery slope in a democracy. Now, I'd like to come back to what Fernando Castillo de la Torre of the European Commission's Legal Service said recently, which is that competition law cases are and should be about law and evidence. And the hope is that this would bring some stability to the discipline and also protect competition law against instrumentalization. So I said law and enforcement, so let's move to public enforcement, which is by competition authorities. And here, public enforcement, that is the prerogative of competition authorities. That is not and should not be the domain of politics. We've had quite some discussion about this in Europe. So we have the ECN Plus directive, which says that the independence of national competition authorities is a cornerstone of European competition law enforcement. And independent authorities need to apply the law without undue influence from the current government. And we've seen some examples in Europe where this hasn't been working so well, which was also a reason why this directive was adopted a few years ago. And that directive also foresees that competition authorities need to be able to set their own priorities, and that this requires financial and organizational independence. So I think from that perspective, very European perhaps, is that this public enforcement should really steer clear of being politicized, or let's say instrumentalized by politics. So no role there.
Right, thank you, Vicky. And then I'd like to invite Maciej, who I think lived through a lot of politicization of competition law, or actually, I guess the legal system in general in his country, in Poland, in the last decade, and that I guess has come to a pause or hopefully a halt with the change of government. So I'm sure Maciej has a lot of insights to share with us. So Maciej, the floor is yours.
Thank you very much. I will, of course, maybe later on I will refer to the examples from let's say my jurisdictions and the research I did. But here there are some fundamental questions that were posed that are certainly the one we need to frame at the beginning. So I think so. I think I will follow on what Vicky just said, but I would argue that politics is a certain surrounding in which competition authorities operate. So I think I agree with you that this idea of competition law being like an island does not hold anymore, and I agree that probably that was never true. And politics is one of the factors that informs how competition law works, and I think so. So the question is really about the relations. I would argue that we may have a fruitful kind of a situation of relation between politics and competition law once we have this relation being structured properly, and I believe that this structured relation is taking place through law, basically. So there is politics, and I would argue that we may have a positive impact. But for example, I will give you the example of merger that might involve some questions that are, let's say, outside the core of competition law goals. If this is happening through, a phone call by the prime minister to the head of the authority, this is not something. I think this is something we would all disagree that is problematic. Whereas, if we have a process during which we could accommodate and build channels for potential governmental input, then it is a slightly different situation. So, but at the same time, I think, and this is in line with what John said, I think competition law, in a way, is if you look at the definition of politics, it's about, there are many definitions, but one of this is really about the exercise of power. So in this sense, if politics is about the exercise of power, then competition authorities play such a role that they impose a limit on what can politicians can do, for example, in the economic field. So there is a risk, like inherent risk, in my opinion, of the clash between competition law and this particularly day-to-day partisan politics. And if you think about industrial policy, if you think about SOEs playing a very important role in some of the economies, then you may actually have a situation where there is a risk of politicization, a problematic one. And this is where the rules that Vicky presented, discussing among others ECN Plus, kicks in. So this is the moment when we need to discuss and think about building proper safeguards of the independence of competition authorities, among others. So to wrap up this part, I would say that I see this relation as a potentially fruitful one, but if we make sure that we have a proper rules for that, and at the same time we need to understand that there is a place for the clash, and we need to build a system in such a way that competition authorities are protected against the intrusion into the decision making, particularly in the individual cases that are pending before competition authorities.
Great, thank you. So finally, we have Soojin. I guess my impression is, I think the politicization of competition law has not been as big of an issue in Korea, if I'm not mistaken. But obviously, please correct me if I'm wrong. But I guess Korea actually presents a very interesting case, because if I'm not mistaken, the chairman of the KFTC is a cabinet member. So in a way, the politicization is already built in and expected in some ways. So Soojin, what are your thoughts on the questions that I posed earlier?
So since many great things have already been said by others, I'm just going to make my comment very short on this question. I just want to echo what John said in the beginning about how competition policy, even in the the so-called technocratic era, was never truly apolitical, and it was always meant to be political to a certain degree, in that it would be influenced from so-called political forces that exist in the larger society. And I think, as Thomas, you have mentioned, that we are often tempted to think that political antitrust or politicization is a bad thing. But as I think Vicky and Maciej try to tell us, it's with rules and framework that would allow us to distinguish what is permissible and appropriate politicization from what is not. I think that's a better framework to approach. And some of the good politicization that we already have in Korea and elsewhere, I think, is we have to set agendas and priorities, which would reflect the priorities of the constituents, and this happens in Korea through participation of the KFTC chairman in the cabinet, as you mentioned, Thomas, and greater policy coordination across all of government that also is inherently political. And also, to a certain extent, it actually is good for political accountability of competition authorities to have some ties to the greater political power and body. So I just wanted to keep my comment short and say I agree with all of the other panelists.
Great, thank you very much. And as I listen to your interventions, I must confess I keep thinking, I think we would have gotten different answers if we had this panel 10 years ago. Of course, we probably wouldn't have had this panel 10 years ago, because this is not even something that a lot of people were thinking about. But I mean, I guess I'm kind of throwing the order of proceedings a little out of order now. But I would like to ask if the four of you, if you think, I mean, this is just something that will ebb and flow over time. It's like a historical pendulum. It will just keep swinging back and forth. This is something, the relationship between politics and competition is something that will just keep evolving over time, swinging back and forth. Hi, is someone is not on mute? I think someone is speaking. I'm not sure. Tanya, I think, is that you? Are you speaking? Are you not on mute? I think we can hear someone speaking. Right, anyway, sorry. So yes, I mean, I'm asking the four of you now a question before we even got to question two, but do you think so? Do you guys agree that this is something that would just keep going, keep swinging back and forth over time? We will never have, this is something that will never stay, I guess, constant. Our understanding of the relationship will always evolve, and what our answer is will always depend on when we ask the question.
But I would say it depends on where you ask the question. So it doesn't have to be that Thomas, that you have, that we might be, looking at these two leading jurisdictions, being the EU and the US. And today, okay, we are waking up. Oh, there are these things going on, and so we are having this panel. But I think it may be that in some jurisdictions this problem were present before. So it didn't attract, let's say, our attention. But yeah, you may have what I would, and there was this what John said about transition. So I would maybe argue that this political role, but maybe a positive role of competition law is growing in a time of a transition. So in a sense that in Poland, you know, the transition from the socialist economy into free market economy, and then you have competition law that actually plays also it's basically also anti-monopoly agenda. So it's in a way more political, and maybe today we are also discussing this for this reason, because we are going through different transitions. So this will be my quick reaction.
Right. Vicky, John, Soojin, do you have anything to say?
Right. I think that's just the thing, right? Politics has always been there in competition. Like John said, it actually came up with competition law or antitrust law. But there are times when this just seems more present, and sometimes where this just seems to be in the background and less explicit, perhaps. So it's definitely, I think, it's just a thing of our time that we have to think about this more again.
Right.
Yeah.
But sorry, John. Yes, please.
Oh, just to agree strenuously with everyone else that, yeah, I think this absolutely will always be there. It'll ebb and flow a little bit, I think. And when a country's economy is doing especially well, I think leadership is happier to let the competition regulators do their little thing off in the corner. But no country's economy has done really well forever. And whenever there's a hiccup or a down turn, I think people start looking around at what can we change, and antitrust has to be on the table. We are part of the government.
Right. And Soojin, do you have anything to add, or should we move on?
Yeah. I think John called it the moderating role of antitrust, but I call it the gap-filling, role of antitrust, which is when we see, big changes in the economy and society, as we have seen in the past, in the recent 10 to 15 years, where we see, rise of big platforms, greater economic concentration, and greater inequality. I think there are economic and social problems that need to be addressed. And I think the pressure is on for antitrust, because I think this was sort of one of the questions that we're supposed to be discussing later. But, if you want new laws, you need to go through the legislative process, which in many countries, in particular under certain administrations, it's very difficult to pass new laws. And antitrust is called up to serve that gap-filling / moderating role, or however you would call it, as some sort of default market intervention mechanism. And I think, this is sort of the era we live in today, where we see that. And that, I think, is when, as Vicky said, where we see the politicization more openly, because there is that demand, and because the social and economic problems that arise from these changes that we see is based on popular beliefs and interests, and therefore they're dealt with more in the news media, and not only in the trade press for antitrust scholars and practitioners, but in the general media, because these are issues that need to be addressed. I think the pendulum has swung really far because of these factors, and we're living in that era right now.
Right. Great. Thank you. But Maciej, let me pick up on your point earlier. You said perhaps it was always there. I mean, it depends on where you ask the question. We are thinking about it more now because the US and the EU seem to be in the throes of increasing politicization, but perhaps in different jurisdictions, it has always been the case. But what do you say to the statement that, yes, that is true, but we didn't, 10, 15 years ago, we would be saying, okay, this is not right. There's too much politicization. This is not what competition law is meant to be. But now we are perhaps more tolerant of it. We seem to say, well, actually, that's how it's always been and how it's supposed to be. And maybe it's always inevitable.
I don't know. I think that the discussion here might be really about the terms and how we understand them, and the term politics and politicization is certainly open to different interpretations. But I would argue that yes, that today maybe there is a time when we are having these fundamental discussions in the competition law. So we discuss, the place of values that are described as non-economic values, or sometimes as public interest values. For me, by the way, protection of competition is in public interest. But there is a time, and we are having this discussion today, and I think this is a valid discussion, and we may, differ. We may have different views on where we sit with the politicization, and to what extent, for example, opening the competition law to non-economic goals, what risks it may bring. But I think there is an aspect that needs to be underlined, is really the politicization where a certain red lines are crossed. And I am trying to distinguish this in my recent paper, where basically I think we need to look for certain metrics where, as a community, we will be able, as an antitrust community, be able to say, okay, this is this bad politicization. The politicization we cannot really agree about. And for me, one of the metrics would be really the depth. So if you have this situation of really direct intrusion into the decision making, and we know about such situations going on, I think the community should react. We should name and blame. But at the same time, it's also the kind of politics. And then I think this links the topic with what Vicky presented. So this, at least for many jurisdictions we are living in that are democracy, competition law is part of this liberal democratic system. And so once you have a kind of politics that is going against the very foundations of liberal democracy, this is, in my opinion, that the politics. So the politicization with illiberal politics is the problem. So if you have a politics that rejects rule of law, that rejects checks and balances, that considers that the state can arbitrarily use its economic power, and this is somehow going down into how competition authorities operate, or how they are supposed to operate. This is the moment when I think we have a problem, and we should think how to prepare competition authorities for such a scenarios, but also be able to name these situations where they actually happen. And unfortunately, I believe that in some jurisdictions, like including the US, the FTC, these are the things that are happening today. So I don't know if this answers your question. I did my best.
No, good, great. I guess now let us move on to the second question, which is, I guess, an assessment of the state of play. What is the extent of politicization, and has there been increasing politicization in recent years in your jurisdiction? And if so, what has been the effect of the politicization in competition policy and enforcement? And I guess the more interesting question is why? What is the reason? The rise of populist politics, the emergence of industrial policy. I guess, for example, in Europe, there's increasing discussion of industrial policy. And I mean, I guess the question is, when we start talking about industrial policy more, is it inevitable that we are also inviting politicization, or I guess Trump? But I guess in a way you can also argue that for the US, maybe it didn't really start with Trump. It started earlier during the Biden administration with Lina Khan. And so we blame a lot of things on the current occupants of the White House. Maybe on this one, we can't entirely blame it on him. So anyway, want to hear your thoughts on what is the extent of politicization and what are the causes. And so I guess we'll start with Soojin, then Maciej, then Vicky and John. Soojin, please.
Okay, thank you. Let me start by talking about US a little bit. I think I have been observing the developments in the US, and I saw, in Korea, and I saw three categories of recent developments that could be described as politicization. The first of which is the expansion of the so-called space for antitrust. So we have seen many newly added goals for competition law. And as Thomas, you mentioned, it started with, a Biden administration, and we saw, new goals such as protection of small business and labor related issues during that time. And, in Trump, I don't have to say more, but we see, for example, in merger policy, we've seen, merger law being used to advance the so-called conservative speech. And why do we see this? I think this kind of goes back to what I have said earlier about sort of the big changes that we see in our economies recently. And antitrust has become a gap-filling market intervention tool. And it is a different question to ask whether this is the appropriate tool to address these goals. But I think it's as a sort of a positive phenomenon. We can observe that antitrust is called upon to do that in the US. And this, I think, may partly be due to what I mentioned before, which is the difficulty of passing new laws. Some of these issues might be better addressed through sectoral regulation or, new system of governing these issues. But antitrust is, as John said, maybe the initial solution to many of the problems that we see. And this is interesting as a Korean because, in our laws, as many of you know, we have fairness provisions, we have general economic concentration provisions, and it was always the Americans who said, oh, that's not antitrust. And what we see in the US recently in expanding this space for antitrust has been beyond anyone's imagination here. Another sort of development that I see is this one also in the US, we have seen many efforts to erase the independent out of independent agencies. And so recently we saw the removal of FTC commissioners that directly conflicts with, what I understand is well-established Supreme Court precedent that the president may remove the commissioners only for cause, but they were removed essentially without cause. And I think this reflects a move for greater executive control over what used to be understood as independent agencies. And this, I don't think, is also just Trump. I think this is a longstanding administrative law issue in the US that predates Trump on the political accountability of these agencies. And as Thomas, you mentioned, in Korea, this is a little different because we are a bit more political in terms of our structure. Unlike in the US, we have our commissioners who serve 3-year terms, whereas the president serves 5-year terms. So essentially, the president can appoint the entire 9-member commission as the president wishes during the term. So we had called our KFTC an independent agency, and yet we have been living under a system where it was much more political compared to the US. And just lastly, I do want to add that in Korea, another development that I've noticed is that our government has stalled all efforts to introduce new law addressing digital platforms. And essentially, they have also stopped enforcing competition law against big US platforms and other companies because of the pressures that come from the United States administration, Trump administration. And we have recently just finalized our trade deal, but before there was much pressure that if we do anything with our competition law or with our new bill, then our entire economy is going to suffer due to Trump tariffs. So that was another development that we saw. And this, I think, is due to sort of the new political economy that we live in today, with a rising protectionism and the the aggravating trade war between the US and China. I'm going to stop there because I spoke too much.
No, great. Thank you. That was a very wide-ranging intervention covering both the US and Korea, and about the international dimensions of all this, the tariff war and everything. But so Maciej, Poland, I guess, and I maybe perhaps in Poland the situation is the reverse. There's less politicization under the new administration. Maybe there's some good news finally from some corner of the world, or not really.
I think it's complex, because this refers to what I said, that if you have a and I think it might be also the situation of the US today, and dismantling of administrative state and independent administrative agencies, having courts being under pressure. It's relatively easy to destroy things, but it's quite difficult then to rebuild them. So I think the situation in Poland today is that the things that happened, actually they continue to have the effects on how legal system generally works. So this includes, under the case law of the Court of Justice of the European Union and the European Court of Human Rights, the chamber of the Polish Supreme Court, that is the last instance in competition law cases, is not a court within the meaning of the EU law and the Council of Europe law. So basically today, if you are like a cartelist, you can claim, and you will arrive to the Supreme Court, you can file today a complaint to European Court of Human Rights in Strasbourg, saying that you are deprived of the right to fair trial. So there is really, a problem, and it's very difficult to fix it. And really quickly, so the question about increasing politicization, I think the consequences in terms of enforcement, and there are some patterns that are similar, I guess, in Poland and maybe also in the US, is the question about politically driven enforcement. So really agencies following the suit of what politicians expect. But also an important question is, I think we should ask ourselves, is where the enforcement is not. So the scenarios of non-enforcement, and a situation where prioritization, which is in a normal world a good thing, can actually serve as a platform for competition agencies to not enforce to not pursue such a cases that can be politically controversial. So I stop here. I don't want to talk too long.
Great. Thank you. Vicky.
Yeah, so when we think of the extent of politicization of EU competition law, I think we can look at three different dimensions: the law, the enforcement, and the lobbying. So when we think of law, I think this is the politicization of old. I mean, in the European Union, we have very clear political values enshrined in the EU treaties. And of course, the court is tasked with implementing them also in competition law. And this has had real effects. So one is, for example, we want to realize an internal market among the 27 EU member states, and EU competition law is actually an important vehicle to achieve this, which to other jurisdictions will seem very outside of competition law, but that is what we do in Europe. If you think of the Constant and Grundig case from the 1960s, that's been going on ever since then. And another thing is effectiveness of EU law. So the court wants to promote that to make the European project work. And in the domain of damages for competition law infringements, for example, in the Courage and Korean case, that was the early 2000s, this became very clear. So in that sense, EU competition law and also what the courts do with the case law is never apolitical. But I think this is a kind of politicization that is unproblematic. Now, when we get to enforcement, I mentioned the ECN Plus directive before. And that applies in the 27 EU member states and has to be implemented. And like I said, the cornerstone is the independence of competition authorities. But of course, the directive does not apply to the European Commission, which is more political because at its helm, it has commissioners with a political mandate that take decisions together as a college of commissioners. And that's true for every single decision taken in EU competition law. Now, in September of this year, the European Commission, or the College of Commissioners, did not adopt the Google AdTech decision as it had initially planned. according to news reports, because there was resistance apparently within the College of Commissioners based on political considerations that are very similar to what Soojin just discussed, which was US tariff threats. And if this is true, then this is definitely an example of the extent of politicization that becomes very problematic. And if we think this even further, I mean, what you certainly do not want is a prime minister or president or a commissioner calling the head of a competition authority or a case handler and going, I want enforcement to go after my business nemesis A, or don't go after B because he's my buddy, although I know he's a cartelist, or you need to okay this merger between C and D because they've donated to my causes and so on. I mean, I wouldn't even file this type of behavior under democratic politics. This is corruption and political instrumentalization. And these are political pressures and interventions on independent enforcement authorities that really undermine the authorities' authority. And they occurred clearly outside of these well-established routes that Maciej has mentioned. So there's no democratic structure to this. Now, coming to the third point I wanted to mention is lobbying. And I think that is another related dimension when we speak about whether politics could capture competition law. Because in lobbying, it's private interests that could capture politics and by extension also competition law and enforcement. And this increasingly appears to be the case, at least from a European perspective, that is perhaps newer than in the US, especially when we consider how large digital platforms are doing everything in their power to make sure certain narratives are heard. For example, this famous competition is just a click away. And this can really shape how competition authorities and legislators understand market dynamics and how they see a need or not to regulate or intervene. And I think this is still really underestimated. And it actually directly concerns us as researchers as well, because we are regularly approached with exciting research projects and funding opportunities. And here I think the question always has to be, how do I preserve my academic integrity and independence? And I think actually linking back to our ASCOLA conference in Chicago earlier this year, our declaration of ethics that we adopted and updated is an important step to ensure that as researchers, we don't play into the hands of those that want to capture politics and that want to capture competition authorities.
Wow, great. Thank you, Vicky. So I guess you would partly blame it on tariff threats by Trump for politicization, and then I guess partly blame it on I guess corporate interests increasingly muscular approach to lobbying as reasons for increasing politicization. And I guess, John, I guess everyone has referred to the US and one way or the other. Now you have the remaining 40 minutes of the panel to tell us what is the extent of politicization in the US.
Well, I will not take 40 minutes, I hope. And I have to thank Soojin for the sort of categorical way of organized thinking about this, because I personally struggle to wrap my mind around what is happening, as I suspect many of us do. So maybe rather than talk about what is currently happening in the US, which is probably unprecedented levels of politicization and frankly corruption, as Vicky called this type of thing correctly. I'll talk a little bit more maybe about causes as I see them. And it's no secret that in the US we've had kind of increased politicization in general and polarization, right? That we are a deeply and sort of starkly divided country. And I think that's along multiple axes and valences, but the one that if you could point to one divide in the US that shows up most starkly, if you look at a, say, presidential election map, it's actually the rural versus urban, and maybe rural and suburban versus urban divide. I pull up an election map of the US in 2024, and it's unbelievable. It's just islands of blue, seas of red around them. And I think we in the competition community are probably as guilty as anybody of sort of forgetting about geographic dispersion of power. I think once upon a time, that really was a very important value of antitrust, at least in the US. Enforcers and judges thought a lot about not just making sure we have small businesses able to compete fairly, but local businesses. And by that, they meant local across the US. not just one giant business headquartered in New York or Chicago or LA. And I think that led to a much less starkly divided along geographic lines country. Over time, that changed drastically. And I think that manifested first in the 2016 election of President Trump, who spoke very directly to that divide, the areas that had been left behind, or at least felt like they'd been left behind. So I think that was a kind of underrated or underappreciated causal factor that led to politicization. And of course, once President Trump is in office, the first time, we saw some really, really problematic decisions made at the antitrust agencies. And then, Thomas, as you pointed out, it's not like antitrust became less politicized while I worked at the FTC, while Lena and Jonathan and Rohit were in office. And I think some of the causes of this are long-term and structural, like I just talked about. Some of them are sort of happenstance. Frankly, I think a pretty substantial reason antitrust was so politicized, especially while Lena was in office, is just because of who Lena is. Frankly, like I think if Lena would have been like a 65-year-old white dude who came up through the big law ranks like everybody else had before, I think she would have been viewed a lot differently. She has a different background. She has different training. She looks different than the sort of standard issue government enforcer in the US. And I think that caused, frankly, a lot of people to just sort of lose the ability to rationally assess what we were doing while she was in office, and was not necessarily through her own choosing, but was the de facto sort of face and figurehead of this new movement. I think that's a big part of it. A lot of what we did was, I think, pretty well grounded in sort of traditional antitrust principles, certainly a more expanded view of who we should be protecting. And I think Lena was pretty conscious about saying, like, let's see if we can bring some cases that would affect those rural areas. For instance, a case to protect farmers, right, against price hikes and exclusive dealing by pesticide or input suppliers. Not to only protect farmers, but to protect everyone, to be really cognizant of antitrust supposedly covering the full US. And I think that naturally led to some more politicization. But I think, getting back to some points by Maciej, there was some good politicization. We tried to make it more democratic. Lena opened up commission meetings to the public, right? She traveled the country listening to farmers, not just listening to CEOs and their high-priced lawyers in DC, but traveling out to the country, listening to farmers, listening to workers for the Kroger-Albertsons merger, et cetera. And all that is politicization of a sense. But I would, getting back to, I think it was Vicky who made this point first, call that a sort of democratic politicization, and a good thing in a liberal democracy rather than a bad thing.
Right. Wow. That was another interesting perspective. So the role of antitrust in addressing, I guess, the rural-urban divide, or I guess the lack of attention. I guess in a way you can argue that our obsession with economic efficiency and our lack of regard for small, medium-sized enterprises saying, okay, they can go, it doesn't matter, in a way has contributed to all this. But I guess the third question, I guess we've all kind of touched on this in the last hour, but I guess we should at least have a point where we bring this all together, which is, I guess the question is, how much is too much? I mean, I think we've all made the point that politics are an inevitable part of competition law enforcement. I mean, Vicky mentioned that EU law is explicitly political. I mean, at least I should say it expressly incorporates political values and market integration and all that. And Soojin mentioned, I mean, the Korean Monopoly Regulation and Fair Trade Act is about fairness, and fairness inevitably involves some politics as well. So I guess we all agree politics, some politics in competition law is inevitable, but I guess the question is, when is it too much? I mean, I guess the obvious answer is, okay, well, corruption, bribery, those are bad, but and I think we all agree. But apart from that, is it just a jurisdiction-specific answer, or is there any general rule that we can, I mean, general, no, I shouldn't say rule, but I guess a general line that we can draw as to how much is too much or not really. So, and now I guess I'd like to ask Maciej to start first, then John, then Soojin, and Vicky. Maciej, please.
Yeah, so I think I already was trying to present my views on that, but basically to recap, it's really that I think we should try, and this is what we are doing here, to try to distinguish between, we can name it that way just for the sake of maybe of a better term, like a good and bad politicization, and think when a bad politicization is taking place. And in my research, and I did the research on Poland and Hungary in the past. Now I'm trying to connect the dots with what's going on in the US. And I think we may argue that a certain kind of politicians, or a certain kind of politics, which I describe as illiberal politics, but one could call it maybe non-democratic or authoritarian leaning politics, is a situation where basically this safeguards in the system that we link with the rule of law are rejected. And we can think about certain blueprint that is at stake, and look for certain patterns that exist across the jurisdiction. So if you have instances of possible non-enforcement because of, you know, competition authorities being afraid that there will be a political backlash, and I think this might be something. This is something I identified in case of Hungary, to an extent when it comes to Poland in the past. Maybe this is something that's going on in the US. We might have this direct intrusion. We may have a situation of dismissals of the competition authority heads without a reason. We may see that, you know, the advocacy efforts of the competition agencies are directly in the line with this short-term political agenda of the party that is at the moment in power. These are, you know, there are these patterns that I think should make us understand that certain red lines have been crossed, and I think as an antitrust community, as I said, we need to name them and try to develop the framework that could help us to distinguish these situations that are clearly negative, and think about proper answers. But I'm reserving this for later. Thank you.
Sure. John.
Well, as it happens, I've been thinking about this a little bit in the context of a paper as well. And the paper is tentatively titled Lawless Antitrust. And one of the goals of the paper is to try to figure out when an exercise of discretion, right, which all agencies have to some extent, when does it cross the line? And that's a hard thing to do. And I decided I can't come up with a sort of bright line rule. So it must be some sort of multi-factor framework, I think. And what I've come up with is a sort of three-factor framework that would ask about the type of decision making, right? Are you doing a kind of thoughtful case-by-case analysis, or are you as an agency head imposing some kind of blanket policy? And then second, what's the reason behind your decision? Is it, as we've said, is it corruption? Or is it, hey, I just don't have enough resources to bring this case, the payoff wouldn't be worth it? And I think that's a probably consensus, legitimate exercise of discretion. And then third, the effect. What is the effect? Is it is your decision going to have the effect of preventing other enforcers from trying to go after this conduct? Is your decision going to create a kind of a de facto immunity, so effectively repeal a democratically enacted statute? That would probably be a consensus bad effect from a decision. So I've got this kind of three-part framework, and then I think we could apply it to a couple of different instances just to get a sense for how it might play out, or how it might apply in the US at least. So in the US, during the supposedly non-political period, there was a blanket decision by both federal agencies to stop enforcing our law against price discrimination. And that prevailed for something like 40 years. It's not a thoughtful case-by-case analysis, right? It's a blanket decision across the board. I think that's problematic. Second, the reason was not resource constraints. In fact, the agencies actually expended resources during that period to oppose enforcement of the law by others. So it's not a resource concern at all. That proves it. Instead, it was just based on ideological disagreement with a democratically enacted statute. I think that's problematic. So strike two. And then the effect was to create at least a partial blanket immunity, right? Because both federal enforcers decided we're not going to enforce that law whatsoever. That's at least a partial repeal in effect. So to my mind, all three factors would weigh against that being legitimate. It's actually illegitimate. It's a lawless decision. Or fast forwarding several years, we could look at something like the decision by the Trump era DOJ to kind of broker a deal to make the T-Mobile and Sprint merger between wireless carriers happen. I think that's case by case. So I suppose that may weakly support finding it to be okay. But the reason was extremely problematic. It was widely rumored that the reason the agencies did that was because President Trump didn't like one of the TV stations criticizing him. Not a good reason, not a legitimate democratic reason to act. And then third, the effect was extremely problematic because by brokering this deal, DOJ was making it harder for the US states, our member states, to bring their own case to challenge the merger, right? So you're not just deciding not to act based on, say, resource constraints, but you're affirmatively acting and making it harder for other enforcers to do their job. I think, to my mind, that would again be a problematic, like, cross the line action. So I think it's not a perfect framework, and I'm looking forward to reading Maciej's work on this as well. But that might be a way to start to think through this question.
Right, great. I guess, I mean, with a problem as intractable as this, I don't think anyone is hoping for a perfect solution or anything close to it, but at least it is a good starting point. Soojin, so what are your thoughts on this?
Well, I also don't have any solution to this problem, but I asked myself, okay, so why are we so scared of politicization of antitrust? Why is our gut sort of response telling us, oh, it could be a very bad thing? And I thought, okay, well, because maybe it could lead to unjust and unfair results, based on your political affiliation. You might get favorable results, or you might get policy that's favorable to you, that's factor one. Another factor would be perhaps the enforcement would be unprincipled. It would be arbitrary. So there would be no way to predict what's going to occur, and it's they're capricious, and it's on we have no idea of how to predict and foresee what's going to occur in this policy area. And I think those are some of the sort of very basic fear that we have. And I think politicization that is unprincipled, that is highly selective based on political preferences, that go against settled expectation, that is not clear and transparent in terms of how they're going to politicize the policy. I think those are some key factors we can all agree are going to be bad politicization. But other than that, I'm still sort of thinking about all this.
Great. Vicky.
Right. So how much is too much? How much politicization can antitrust take? I think politicization becomes too much when the threshold is reached where it goes beyond the boundaries of the democratic structure we've been discussing. So where competition law essentially is instrumentalized. And lately, we have been seeing increasing evidence of political instrumentalization, and that is just where it gets dangerous, because it puts into question the legitimacy of competition law itself, and it also jeopardizes the integrity of competition enforcement. Now, looking at what we've seen in the European Union, I'm slightly optimistic, despite this recent Google AdTech episode, because in the end, Google AdTech, the decision was adopted, and I think it's an important one. So they were able to overcome this. I'm a bit more pessimistic when I look at some other examples. So we haven't mentioned the UK, but there this year, the former chair of the Competition and Markets Authority was politically pressured to step down. And he was then replaced by a former Amazon executive. And I think this sets a dangerous precedent of political meddling that is not what we should strive for. And also when we look to the US, I mean, Soojin already discussed this, where the members of the Federal Trade Commission, the two Democratic members, were removed without cause and not replaced. I mean, this puts an entire bipartisan agency into peril because the law, as I understand it as a European, but the US law foresees a bipartisan agency, and that's part of checks and balances. So a democratic necessity. And I mean, we will soon find out whether the US Supreme Court has become so politicized that it closes both eyes. But I think what we need to do in these turbulent times is just to have our eyes wide open and acknowledge these incidences.
Right, great. And that actually is a great segue to our last question, which is always the most important one. What can we do about it? I think I was reading something about the importance of remedies in antitrust. If we're going to if we decide to tackle an issue, we should have some solutions. So, but I guess in a slightly different context, we're looking at the same issue. We are discussing the politicization of antitrust, of competition law. We've talked about it at some length now, so I guess it comes to the show me the money. What can we do? Vicky, Soojin, John, and Maciej. Vicky,
Okay,
please.
so what can we do? Like you said, that's the million-dollar question. I believe there is a lot we can do, although it sometimes doesn't feel like it. But I think we ought to really raise our voices in the face of this political instrumentalization, because no matter whether the outcomes are aligned with our worldview or our political leanings, it will always be a loss for our discipline. It undermines the analytical framework. It puts into question whether an area of the law that is supposed to keep private power in check may not actually be serving a very different kind of power. And like you said, in my ongoing research project, one of the core issues I'm looking at is how can we protect democratic values with competition law? So this is closely related to our discussion today. And of course, as the first step is raising awareness about this issue, it's really important to be talking about this, like here at ASCOLA NOEL. Earlier this year, the OECD hosted a competition roundtable on corporate capture, which I found very, very insightful. A few weeks ago, Ariel Ezrahi published a contribution on political instrumentalization of antitrust and pro-market, which I encourage you to read. So there's a lot of awareness that still needs to be raised. I think as a competition community, we also need to insist on the value of a competition law system based on the rule of law with predictable and transparent rules and independent competition authorities. Because an attack on the agency independence is ultimately an attack on competition law's goals and an attempt to subvert due process. I think, like I said before, the courts will have an important role to play, but they can only do this if their independence is guaranteed. And it seems that some jurisdictions are doing a better job at ensuring this than others. And for us as researchers, I think the imperative is also do research on this. So that is what I'd like to encourage everyone to do.
Wow, great, great, great. Soojin.
Oh, I echo many of the points that Vicky raised. I think, as researchers, we need to look at, whether the checks and balances that have been put in place in each jurisdiction are working well, and I think commonly many jurisdictions look to judicial review as a check to politicization of antitrust, if you will. And I do think that the report card for judicial review depends on each of the jurisdiction, but I'm currently working on a paper on whether judicial review is working well in South Korea, and I hope that this is a valuable research in that regard. So I think it's important to pay attention to the checks and balances. Also, I also want to echo what Vicky said earlier about legitimacy of competition regime in general from the perspective of the newly developing competition regimes. The politicization of antitrust in the US and other main jurisdictions, I think it would have a tremendous effect, negative effect on these newly developing jurisdictions as they look to a principled approach, and they need to persuade their own government and the powerful people that this is a necessary policy. This is a policy that will, be it's what they need for their economies. And when we see unprincipled bad politicization, it's going to hurt their case a lot. So not that this is something that's going to motivate changes in the main jurisdictions. I think it's an aspect that we still have to consider in losing the legitimacy. It's not only within US or within EU, but now since competition regime has been exported to many countries around the world, this has ramifications beyond the boundaries of the politicized jurisdictions.
Great, Soojin. And John, so I guess one related question is a more economic approach or more law approach better at minimizing politicization? And I guess just to play devil's advocate a little bit, I guess I'm not a Chicago school person, but if I were to put on that hat, I would say, well, we told you, once you start going down the slippery slope, you just can't. I mean, if we stray from economic efficiency and consumer welfare and make it value neutral, we open the floodgate, I mean, choose your metaphor, and basically it's inevitable that we will get to the quagmire that we're in. Do you agree? Or yeah, what are your thoughts on that?
Well, it's a great question. It's an interesting question. And there's some like unique US pathologies around this question. So my answer might be a little bit US specific. But I don't think either a more law or more economic approach necessarily staves off politicization of antitrust. I think to some extent, as I've said before, I think to some extent there are external factors at play here. And whatever approach we choose to use inside our discipline is not going to prevent politicization of our field. In the US, we tried what you would probably call a more economic approach for about 40 years. Point one, that did not mean antitrust was apolitical. And I think that to Vicky's call for scholarship, I think scholars also, especially the folks who are on this call, could do a good job of sort of rejecting that political-apolitical divide that some commentators have tried to throw at antitrust reformers. So antitrust was never apolitical during that period, even if it was a more economic approach. It was not especially politicized, but I think it was laying the groundwork. It was kind of creating fuel for the fire that led to this current moment that we're in. So I don't think it was staving off politicization. If anything, it was kind of ensuring that at some point this field would become politicized. I've been something of an advocate for a more law approach instead of a more economic approach, but I'm not sure that's a guarantee either of a non-politicized antitrust, because we need leaders who will actually follow it, right? It's one thing to say we're adopting an approach, but it's another to actually abide by it. And I do think we have some leadership in place at the FTC right now who have said that they are going to stick with a more law approach. They've left the merger guidelines in place, which have more law in them than they used to. But I'm not sure that they're at all following an actual more law approach. So adopting an approach is one thing, but we would still need leadership who will actually abide by it if we're going to have true rule of law. So I do think more law as an approach is essential for a system that respects rule of law. How can you have rule of law without some role for law, right? But it's not enough. It's a necessary but not essential step to getting there.
Great, John. Actually, that's a good segue to Maciej's turn. Rule of law, as John said, if what is the point of talking about legal approach when there is no one, I mean, when the authorities are not enforcing the law the way they're supposed to, when no one is following the law. And I guess, what do you think, I mean, in terms of focusing on, I guess, shoring up the independence of competition authorities? I mean, I guess, especially from your experience in Poland, or from other jurisdictions as well.
Yeah, so I agree with what was said, that particularly today, I think I was always defending the idea of independent competition authorities. Sometimes I heard the criticism, but if you have these independent authorities, they are in a way undemocratic because, you know, they are too insulated. So it's maybe a difficult exercise that we are walking, but clearly I think the time we are living and the experiences we have with this kind of illiberal politics I described is that the safeguards of independence are needed. I believe that Vicky discussed the ECN Plus directive. I don't think they go far enough. So, for example, in the ECN Plus directive, you have certain rules, but basically the process of appointment just needs to be transparent. So it is possible that you will have an active politician being appointed as the head of the competition agency. But for sure, I am in favor of the term. It's not perfect, but it gives certain safeguards. I am in favor of a properly built process of appointment of the heads of the agencies. I have in my research this problem with under-enforcement. So, and this question about prioritization, as I said. So I would argue that, of course, competition agency needs to enjoy a certain space of freedom where they want to enforce at a given moment, but it should be done in a more transparent way. So certain information about what kind of cases are not brought by the agencies would be helpful in the context of independently driven enforcement. And two last points very quickly. Judicial review, very important, and we need to remember about the courts. I think we focus a little bit too much on competition agencies. Courts are equally important actors in the competition law, but we cannot believe that the courts will save us, because courts are subject to the same processes as competition authorities are, and we may have a problem with the independence of judiciary as well. And the last point is really about international cooperation. I think that the bodies that are maybe sometimes criticized, like the ICN, actually can help this cooperation and this kind of that the agencies have allies abroad, not just in the academic community, but also in their counterparts. That's the important part of the picture, that agencies of a given country are kind of not left alone when they are subject to political pressure from the government.
Right, great. Thank you very much to the four of you for very insightful interventions. And I guess in the 10 minutes we have left, I guess I should open the floor to questions from the audience. I'm sure there are many questions on such an interesting and a pertinent topic. So please, anyone who has a question, you can just use the hand raising function on Zoom, or you can just speak directly. Anyone? Questions from the audience? Is there anyone who has a question for any of our four speakers, or all four of them? Right. So actually, I was thinking, Maciej, you seem to, I guess you clearly believe in the importance of an independent agency, and at the same time, I guess there's also the recognition that you can't really keep politics out of it. And so do you think there's a tension? How can we, how can we allow politics a proper role to play in enforcement and while not undermining the independence of the agency? Should we just focus on appointment procedures, appropriations, or are there other things we need to worry about? Or you also mentioned judicial review, obviously, but yeah, so how do we make sure that we allow room for a proper play of political considerations without undermining the independence of the agency?
But I think there is a growing research on the role of, you know, these other stakeholders within the decision-making process. So like the place of third parties in the process. Also thinking how the decision-making bodies within the agencies should be built. So it's really, on one hand, I am in favor of independence, but at the same time, it shouldn't lead to the situation that we have, you know, this technocrats that are sitting there and they don't care in practice about you know the real world that is around them. So like the creating procedures that provide for the place for the input from different actors. This is one of the solutions I see. The other one would be potentially like collegial bodies that would be, you know, more open for providing a place for different views, and also for you know maybe representatives of different origins. I'm thinking about other areas of law where this might be working and be a source of inspiration. So I would think in a way keeping independence, but at the same time opening the agencies to this good societal input that competition authorities should receive.
Right. Actually, we have a question from Ruprecht, and so his question is, I guess, slightly playing devil's advocate. His question is whether we're detecting increasing politicization these days because we are doing a better job of detecting it, or there's greater transparency in the process so that we observe the politicization, so that actually things have not gotten that much worse. We're just seeing it more, or are we just deluding ourselves into thinking that things are not as bad as they are? Yes, any of you has any thought on that?
Not a very well thought out thought, because Ruprecht, as usual, has come with something I have not thought about before. But I think the answer, my initial answer would be at least a little of both. You know, I think it is right that today there are more people, there are just more eyes on the competition authorities than there probably ever have been before. And there are also more ways for people to report what they're seeing in a digital world that just didn't exist, say, back in the US when President Nixon was doing his corrupt things in office. So I think there's something to that, probably, that there just are more eyes on this. It's the same reason that you know, people are scared to go out at night in the US. Well, there's just more reporting on crime. There's actually not more crime. So I think there's something to that. Though I think that we should not overlook the contributions that investigative reporters in particular have always played throughout antitrust history, going all the way back in the US to the famous Standard Oil case. That really emanated out of deep investigative journalism by Ida Tarbell and others. And the same thing happened with the Nixon scandal in the early 1970s in the US. That came to light because of investigative journalism. Right? It was a newspaper columnist who first published a leaked memo that detailed what was happening between ITT and President Nixon. So it was a first kind of really clear example of corruption and antitrust in the US. Also came to light because of investigative journalism. So yeah, I think there's a lot of like citizen reporters out there with smartphones, and that's a good thing in general. But it can't replace the work of deep investigative journalism as well.
So
Right. Yeah, Vicky.
Maybe adding to that, I mean, obviously these kinds of getting into politics and then the law, this has been going on for a long time. If you something I read recently is by the Mullins brothers, The Wolves of K Street. So this goes back many decades, this influence peddling. But I do think that I'm less optimistic than you, Ruprecht, I'm afraid. I do think that the boldness with which this is happening really shows us that this is not really politicization, it's really instrumentalizing politics to a non-democratic degree. And so I think we do need to be worried and look into this.
But Vicky, do you think we know more about this now? Because I guess it's hard to hide. I mean, I think you focus on big tech and the lobbying and the influence and the process. Do you think there's greater transparency of what they're doing? Because I guess so much focus is on them now.
I think there could still be more transparency. I mean, if you look at, for instance, I've been looking into astroturfing recently. So big tech companies setting up or contributing to these, well, it looks like grassroots organizations or independent think tanks that in the end turn out to just, be there to share the view from small businesses, but actually it's the view of the big tech company behind it. So there's a lot of blindsiding going on still that lots of NGOs are looking into. And I think there's not enough transparency in this regard. So there can be more transparency because we have maybe different tools to look into this. But I think there still needs to be more.
Right. So I guess maybe I'll give everyone 30 seconds to speak your last thoughts on the issue before we bring this to a close. I guess, shall we start with John?
Sure. I'll maybe encapsulate the things that I'm taking away from this. I think there seems to be general agreement that antitrust has always been political, and that's okay. I think there seems to be general agreement that politicization of antitrust can be good or bad. It is not necessarily a bad thing. If it takes the form of more democratic engagement with agencies, for example, it's a good thing. I think where we all also have a consensus, though, is Vicky's word, instrumentalization. I think when the agencies become the instruments of anti-democratic political ends, that is a consensus bad thing. And finally and last, and not to end on a cynical note, but it is a bit of a dark subject, I think there's more of that happening now, at least in the US, than there ever has been in history.
So, Ruprecht, the answer to your question is no. Right. Soojin.
Yeah, and also to add to that, I question the premise whether there is actually greater transparency when it comes to the lobbying money flowing into the big from the big companies through super PACs and other things in the US. So I question the premise too. I guess my takeaway also is that it's something that we really need to sit down and research and think about in order to distinguish how to present a framework that would be able to distinguish the acceptable, permissible politicization from the ones that are not. And I think we suggested sort of the big principles, but the nitty-gritty details need to be worked out. So that's something for all of us to take home and think about and work on. And I think just to echo what Maciej has said, I think international cooperation on this would be important. As I mentioned, it's not just about the few jurisdictions, it's really about the international community as a whole. And so that is something that I think also needs to be worked on. Thank you. Thank you, everyone, for a great discussion.
Maciej.
Yeah, so I think I agree. Maybe on this instrumentalization, that's true. I completely agree. But I would add to this, because we are in a way thinking that it's just about, competition authorities being used for this short-term bad political purposes. But it's but I think the risk also is that the competition authority will become meaningless. So in a sense that they might be used as a tool for the politics, but at the same time there is a risk that there will be nothing else left. So they will stop really doing their job, and this might be even more dangerous for the system and for the discipline than these instances in which we have kind of politically driven enforcements, particularly these scenarios of non-enforcement, where basically competition authorities would be afraid of enforcing the law in line with the law. So I would add this to the list, and then I agree we need to think more how to build it properly, and also think about proper safeguards, and that should make both courts and competition authorities free from this problematic politicization.
Wow, Maciej. Ruprecht was trying to cheer us up, but you are making us more and more depressed. You're talking about the whole the competition authorities and the complete nullification of our discipline. No. But Vicky.
Right. So what are my takeaways from today's discussion? I think there is an important role for politics and competition law, but it should not allow for political instrumentalization. And I believe there really is a fundamental difference between the two. And recent examples from many jurisdictions are quite worrying. I think as a competition law community, it's our job to raise awareness about how this can threaten the entire competition law system. And it's our job to contribute to understanding this better. And to end this on a more optimistic note, hopefully we can come up with some solutions.
Right. I mean, I can't help but think that maybe after this discussion and all the great ideas that the four of you have come up with, you guys should co-author an article together, bringing all your perspectives from different jurisdictions together, but just an idea. Anyway, thank you very much to the four of you, Vicky, John, Soojin, and Maciej, for your insightful interventions, great discussions, and bringing in perspectives from different jurisdictions, and I guess slightly different thoughts and perspectives as well. And this is exactly what makes ASCOLA great. And Soojin, it's almost midnight. Sorry about this. And yes, so I guess I would like to bring this to a close. And thank you very much to everyone for attending, and to the four of you for speaking. Thank you very much.
Thank you, Thomas.
Thank you.
Thank you, everybody.
Thank you. Bye.